in early 2022, there was a leak from the Imperial Oil's Kearl oil sands plant that was reported to the Alberta Energy Regulator, but the information wasn't released to the surrounding Indigenous communities or the general public. Then in the spring of 2023, there was a 5.9 million liter spill of industrial wastewater at the same plant. And that then all of the information came out, and it's been a hugely controversial story. And just yesterday, the AER released its 9-month investigation, the report on that investigation to the public. And I'm going to talk to Professor Martin Olszynski, who's with the University of Calgary. He's a specialist in environmental law, about the report. So welcome to the interview, Martin.
Thanks, Markham.
Now, my media colleagues have been reporting on the half of the report that says the AER basically followed its existing policies and procedures, and it kind of giving them a free pass for their performance. But the real meat of this report lies in other areas. Give me your take on it.
Yeah, I mean, fundamentally, it's not hard to conclude that you didn't break or contravene your rules and procedures if they are inadequate or missing in the first place, right? And so one of the problems, and I think some media outlets have tried to make this point, is that while there was this purported compliance with internal policies and protocols, most of them are deficient, right? They are missing important parts, and Deloitte goes on to suggest recommendations for how these policies should be improved. And it's really in there, as you say, when you read the fine print on what was missing, that you start to see that, frankly, it appears that the regulator is working in a very ad hoc manner, and doesn't really have the protocols and procedures in place that it should have, and frankly, that are inconsistent with Deloitte's own sort of like conception of emergency response.
Now, there's also some issues that you have with the report itself and what's in it and what isn't in it.
Yeah, so I mean, fundamentally, and we were all concerned about this when we found out that that's, when this had all happened and the board decided to have an investigation, they didn't appoint a judge, as we might in the case of a public inquiry. Even in the context here in Alberta, we're dealing with this really tragic E. coli outbreak, and we recently have had a member of a former member of the Calgary Police Service, I think, or the fire service, appointed to lead an inquiry, and they're going to get to the bottom of it. But they appointed Deloitte, right? Which is their job isn't to act as a quasi-judicial sort of like inquiry. They looked at the papers, they look at procedures, and then they make these sort of like high-level policy recommendations. So for instance, what's glaringly missing, of course, from this report is any any clarity about what actually happened in this instance. What were the decisions? We can infer, and it's mentioned somewhere in the fine print that, as between an incident and an emergency, this initial May 2022 spill was deemed an incident, but we don't have any of the supporting rationale for why that was the case. We aren't aware, we've been provided no records about any kind of consultation or analysis that was done within the regulator between different levels of management to determine whether or not that was in fact appropriate. And nothing really by way of explanation to why it took 9 months, frankly, and a second spill for this to become public knowledge, right? So as a starting position, the report was framed and scoped in such a way as to avoid answering the really important stuff, which is what happened. So that's gone. That's not even there, and that's not. And frankly, maybe it will require a court of law, in the context of potential legal action. And several First Nations are already sort of intimating that they are interested in doing that. But so we have nothing there, and so then we just get this very mille to quo statement that, well, you complied with your policies, but frankly, your policies are badly inadequate.
Well, of the 4 areas that Deloitte has identified as being deficient, one of them is policies and procedures. They're dated and not in line. Now, Deloitte has this model that it uses. It calls it the Global Framework for Crisis and Incident Response. So the policies and procedures were deemed to be not up to date with that model. That's number one. Secondly, the terminology and clarity in the documentation is way too murky and imprecise. And you and I have had interviews previously about how much discretion is in the legislation and the regulations around the AER. So the Deloitte identifies that as a deficiency. There's no timeline or requirements to escalate things up to the board level. And fourthly, communications and stakeholder engagement, quote unquote, does not explicitly consider the expectations of Indigenous peoples. Taken as a whole, policies and procedures, frameworks, communications, this is really, to me, it's an indictment of the regulator.
Yeah, I totally agree. And yeah, fundamental things, so again, it's not shocking. It's not surprising when someone says that you complied with this stuff, because it is lacking in so much important detail and in so many formalized protocols. Simple things like, when does the regulator rely on industry sampling? When does it carry out its own sampling? Or, as you noted, is there a time period after which a response has to be completed by? None of that's there. So of course you can comply with nothing, right? That's not hard. So no, absolutely. I think it absolutely is the case that when you read the fine print of this report, and they've written it in a very sort of there seems to be this attempt to be very collegial and not antagonistic, not to be overly critical. But if you actually read the fine print and you read what they say is missing, it's a pretty damning report. Notwithstanding the fact that it, of course, still, like I say, omits the most important information, which is what actually happened in this instance.
Now, the version of the report that I had access to, Martin, never once in that document does it mention the word data. And this is a really interesting issue because there was both a spill and a leak. There were allegations that the contaminated water leaked off the Kearl site. There was a lot of controversy there. I know when the spill happened, I asked the AER for data that could be verified by independent third-party scientists. They refused to provide that data. And given the problems that the AER has overall with managing data, releasing data, using industry data, the exclusion of data from this kind of analysis seems to be a huge hole.
For sure. Again, it wasn't designed. This is in no way, shape, or form is this something that this report is something that you could look at to say, here's what happened, here's the transparency around our decision making, here's how we made our decisions, here's how we justified them, here's the analysis that we did. None of that is here. And again, not surprising. Everyone, most of us observing this situation when Deloitte was picked, when the terms of reference were sort of put together, it became apparent that this wasn't going to answer those really important questions. And so, yeah, we're stuck. We're stuck for now, anyways, for the time being. I think that these questions are outstanding. I think, if anything, again, is it useful to know that the AER's internal policies are totally inadequate? Yes. That is useful information, but it's not anywhere near the most important information here.
Well, that leads me to the question of what should the AER have done?
Well, frankly, what they should have done is hired a former judge. They should have asked a former judge to investigate, and she would have the power, he or she would have the power to interview staff, to get that information put before them, to look at the data, and to explain how things went the way they went and why decisions were made the way that they were made. And then on the basis of that, she could then say, here's where things went sideways, or or maybe, frankly, and this is the thing that the AER obviously passed up for itself, maybe he or she would have said, well, this was reasonable in the circumstances. But they weren't prepared to have that kind of scrutiny. They're not prepared to have that kind of scrutiny, transparency, and accountability. And therefore, they came up with this, very much paper-focused exercise of, did they comply with their own policies? Frankly, it's, I don't want to say it's totally irrelevant. Like I said, that's useful information, but it's not nearly the information that we were all hoping for. And like I said, what I think it means is that there's going to be, it gives that impression again now that the AER is in fact hiding something. And I can't help but think that that's going to affect First Nations, for instance, when they're considering their legal options right now.
Already a couple of First Nations have commented on this, and they've said that the AER is a captured regulator and they have completely lost trust. Trust has been broken, and they're asking the federal government again to step in and use its authority come up with some kind of an oversight board or some kind of regulatory using federal authorities. Where does that leave us in terms of the AER's credibility and what should be a go-forward strategy?
I mean, it's interesting. Like in this space, of course, as a general rule, I think anytime in Alberta you try to bring the feds in, it's a problematic proposition, right? Because we already, I mean, in unrelated news, we already know, like in relation to the clean energy regulations, apparently the premier's already drafting her first Sovereignty Act motion or whatever it is. So it's already, so the idea of bringing in the feds, on the one hand, I want to say, your issue is with the province, so you should stick to holding the province accountable. Bringing the feds in doesn't necessarily get you any further, and in a sense allows the province to escape the accountability that it should be compelled to sort of like take on. Why I think it might be a little different in this circumstance is because the federal jurisdiction is much more clear. So this is the Lower Athabasca region. We're talking about leaching, we're talking about spills, we're talking about fish-bearing waters. There's no question that the federal government has a clear constitutional hook here in terms of its legislative authority over fisheries, inland fisheries, fish and fish habitat. And so as a result of that, there is scope, I think, to say the province has botched this. And it's true that for the past 15 years, I mean, the federal government has taken a very hands-off approach to questions around tailings management, reclamation, remediation, all of these things under the sort of idea that this is, falls within the province's wheelhouse. We'll let them deal with it. We'll apply a light touch. But I think what we're seeing and what First Nations are going to increasingly be demanding is like, no, look, these waters, these are your jurisdiction, and you're going to start having to assert that jurisdiction in a much more muscular way to ensure that we aren't left holding the bag on these massive liabilities, basically. So we'll have to see how it plays out. I think the current federal government is probably more amenable to playing more of a muscular role here than any previous federal government. But I will go back to what I sort of said, and I'll reiterate, like in my view, you can bring in the feds, but it would be unfortunate if there wasn't an attempt also to hold the province accountable, because this is frankly the province's, on this issue, this is the province dropping the ball.
Now, Martin, the industry and the government have claimed for years and years and years that the Alberta Energy Regulator is world-class. In fact, they claim that it's the best oil and gas regulator in the world. And is it fair to say that this report actually leaves that reputation in tatters if it wasn't prior to?
Yeah, I mean, exactly. I mean, I don't know how many more tatters. It's tatters upon tatters, right? I mean, you might remember when the coal policy was rescinded and they struck together a coal policy committee, and the chair there at one point, they commissioned an interview, and 85% of Albertans said they had no faith in the regulator. And he was in the news speaking about this because he was so bothered by it. And so again, tatters of tatters, I guess, at this point. I mean, I don't think anybody thinks that it is a credible regulator anymore. One of the things I think that industry likes to say to itself is they get into this relativistic space. And so they say, well, okay, we're not great, but have you seen what's going on in Africa? Or have you seen what's going on in some of these other places? And, I mean, my own view is that what's happening in that is really, really not that relevant when what we're seeing is these kinds of effects and impacts on our local landscape and our local watersheds and our airsheds and whatever else it is. And so, are they better than regulators in Nigeria? Probably. Are they good regulators in a developed democracy like Canada's? No, they're not. They're not anywhere near that. They are increasingly clearly, and this is becoming, clear in various contexts, they don't appear to have the will to do the hard work to regulate this industry.
Well, Martin, thank you very much for this. Really appreciate your insights.
You're very welcome.